Mahuta.
Mr Speaker, I acknowledge the contribution of the Minister and tend to agree that this isn't the time for long speeches, but it is the time to go through in some manner the issues that were raised before the Select Committee insofar as the submissions were concerned. They were substantial in our view. We do have a thorough report, Minister, preceding the second reading, which bring together the substance of our considerations, and we, in good faith to those submitters, tried to whittle down to the key components of their expectations, in some respects objections, in some respects to aspects of the settlement. I do believe that the Select Committee got to the right place in our deliberations, and want to commend the officials for the way in which they helped advise. All but one issue what has been resolved by the Select Committee, and I understand, Minister, that you will be continuing discussions on that front, and perhaps the House will be of a mind to consider your response in the committee stages. So let me go to the submission process. We went to Whakatane and heard a number of submitters. We received around about 66 submissions in total. 42 were in favour, 14 were opposed, and 10 presented a view neither one way or the other. Can I say that they, as I worked through the bill and tried to give it some consideration, there were the issues around Ruapani. There were the issues around the national park itself and aspirations for management, how that might take place, the consequent impact on groups like Fish and Game and that community and hunters. There was a very strong representation from Te Tira Whakaemi, and also there were I guess some reflections in a number of submissions around public access provisions for Te Uruwera, and also how the Management Board would conduct its very important obligation for this wonderful place. As we work through each of those issues, in some respect, it was helpful to know that the Minister had given an indication to Ruapani that there would be a process for them in terms of their settlement, that Onepoto would be set aside in terms of addressing their interests. And that was certainly very helpful as we went through and considered the extent of their interest in Waikare Moana. The issue of the ownership of the lake bed came up. And we sought advice from Parliamentary Council just to give confidence that what was actually said and intended in the legislation was indeed the case. The lake bed isn't factored into the settlement. However, we did receive, I guess, submissions which tended to insinuate that the consequent effect of having a Te Uruwera board, a management board for the National Park Estate, would have an impact on the lake bed. And we have clarified that within our commentary. We were also mindful that in regards to the Lake Waikare Moana reserves, there was also a parallel process continuing through the Māori Land Court. During the course of our deliberations, we received the judgment of Judge Fox, and we then were in a position to pursue clarification around, I think it was Clause 91, and whether the interests of those 13 reserves could transfer to the Ahu Whenua Trust, as was directed by Judge Fox. We have received and we received clarification from the OTS officials who assured us that yes, that is the case. The other aspect that we were mindful of was in relation to I think Fish and Game's interpretation of the management plans that would be developed and how it would infringe on their existing rights. And I know the Speaker from the hunting community would be quite acute to those types of interests. And in all honesty, I certainly expressed, and members of the committee agreed, that this is a new normal. for many members of the wider community, insofar as it is the intention and the way in which the Te Uruwera Board will operate, that management plans will be developed. There is the provision for consultation to occur, but again, all those issues will be lifted up to the board and have consequent effect not only on hunters and fishers, but also tuhoe themselves in carrying out the obligation for the custodial protection of Te Uruwera. I want to point to what I believe is a very strong and innovative approach to custodial care, kaitiakitanga, good stewardship, and that's in parts 5 to 7 of the bill around Te Uruwera specifically. If we look at clauses 110 to 112, within the components of this bill is a really good, I think, example of how we can draw on the provisions of an area which is unique and rich in context, history and ecological value to be able to affirm its own unique identity in Māori. I'm particularly mindful of these clauses and provisions, Minister, because I know that the Hauraki settlement is hoping to follow quickly behind this one, and I want to draw the attention of those listening to the House from Hauraki that this is an area where I believe there are some good foundations to be followed in how you can look at being the custodials of your conservation estate. The public access provisions in particular, they have been set out in clauses 112 subsection 2, which and also 176 subsections 1D, where there are issues around public access, the creation of bylaws. Now, again, I draw the attention of the House of Members here around those provisions because, to some extent, people might have got it in their heads that, and I know this was certainly the narrative prior to seeing the detail of the legislation, that if tuhoe take over the management of Te Uruwera, then public access would be prevented. That is indeed not the case. And it is clearly set out in sections of the bill where not only public access is preserved, but for very specific reasons, bylaws can be created to be able to limit public access for specific purposes. There is opportunity also through the management plans for the public to have input. So I think it is very important to draw the attention again of those listening to this bill with some intent to assure them that public access continues. There is a management regime in place. There is the opportunity for public input. There are provisions for better management tools to be implemented for specific reasons, and we should be confident that a board with the range of interests represented can approach the long-term management and caring for Te Uruwera in a way that better meets the needs of everyone in the community. I am very pleased, of all the settlement bills that we've got to, I'm very pleased with the committee's report and thank the Chair of the Māori Affairs Select Committee for being so accommodating to all the concerns that have been raised by the members. And your accommodation of those concerns allowed us to pursue with some vigour aspects that needed to be done so that when this bill goes into the third reading, it has the full support, I hope, of members of this House. Minister, can I just lastly assure you that should your discussions with Ngāti Manawa and Tuhoe be successful to the degree that we are able to sort out the issues of the transfer of the remaining 2 properties, we would welcome further discussion in that space, and we look forward to perhaps that detailed opportunity in the committee stages. Tēnā tātou katoa.
Honourable Dr. Peter Sharples.
Tēnā koe, Mr. Speaker.